the declaration you can add to it. You don't homeschool your kids?
I don't have kids.
Okay, we did this for, we homeschool, so you fill out this declaration annually. It says, declared my intent to homeschool my kids. Now they're adding to that a little more information. If my kid came from public and private school, it sounds like that.
I got here's what I got a ton of homeschool. It's somewhere before I got a ton of homeschool.
Oh yeah, absolutely.
So my actually used to be inclined to throw it all down so I'm safe.
Well, no is only safe, except for with leadership here. This is all fine now.
public school with documentation to the central office of the local school system, such local school system shall notify each public school. The local school system shall notify such public school. In the event that the child's prior attendance and disciplinary record, observation from the child's teachers and school personnel, or any other involvement of the family with law enforcement of the Division of Family and Children's Services of the Department of Human Services present any evidence of neglect, the school should make a report pursuant to Code Section 1975. In the event that a child is withdrawn from a public school without documentation, or a child stops attending a public school for an extended period of time and cannot be located, the school shall refer the matter to the Division of Family and Children's Services of the Department of Human Resources to conduct a thorough investigation. And that's essentially the bill.
Okay. Thank you, Chairman. And I, just to kind of clarify the intent, and as somebody who actually did student teaching in an elementary school, you know, those children that, you know, we're trying to get at are the vulnerable children. You know, every teacher knows those kids. The kids that come to school, you know, the 5-year-old that comes to kindergarten in shorts in January, the kid that maybe has hygiene issues, maybe comes to school hungry, maybe the teacher has not seen anything overt, but certainly has seen some red flags, and that hopefully it is hoped that that notification requirement that that child will not be under the purview or care of that teacher might, you know, warrant the teacher in their own discretion making a report. So I will, members of the committee, do you have any questions for Chairman Hitchens? Representative Cantrell. Oh. Representative Gullett.
Thank you. Thank you, Madam Chair. I have a question related to line 32 and 33 in there. You didn't cover it, but it says the declaration shall state the name and location of the child's current or immediately prior public or private school or kindergarten or pre-kindergarten program. Can you tell me a little bit of the background of what that's doing and why we're asking for it?
Well, I must have got one of the copies that wasn't put together well, because I'm missing the whole second page. I didn't read any part of it.
We will get you a copy of that.
Yeah, well, Calder just gave me a copy,
thank
but
you.
I didn't even see that. Why would that be in there?
Yeah, why are we adding that? I'm not sure what it does, and if you can give me a little background, maybe I can understand what we're trying to get at by collecting that data.
I believe they would want information. If you go back to the school where they came from, and if you're looking for information about it.
But we haven't collected this data before. Is that correct? As far as we know, I mean, it's new, it's underlined to me. So it's today we don't ask that we don't.
Well, it would be in addition to the
data that we collect.
You know,
now
and a lot of times when these things happen, you know, it's a totality of things that have gone on for a long time. It may not be one instance. As the chairwoman says, you know, you see things as they come along, and one in itself may not cause you to make a report, but when you look at it long term, and there are a lot of things going on, it certainly might cause you to, and they want to get a copy of all the records, and if they're going to refer back.
So just so and I'm not challenged. I'm just trying to understand how this is going to help the problem. Is kind of where I'm at. So today, when you become a homeschooler, or say my child is in 4th grade, end of school year, I make the declaration that I'm going to homeschool for 5th grade. Of the information that we're asking, this is additional information that we're asking. I'm just trying to understand, other than what are we going to do with that data? I guess that's what I'm trying to figure out. How does it help the situation? Any situation related to the children? Is it for us to go back and understand what's going on with in prior? I'm just trying to understand how it helps. And
I haven't had anything to do with the recent writing, and I think all of you know Calder Charles here, who works in the leader's office, and Calder has worked on this thing diligently now for 2 months, and I'm gonna let him speak to it because he has much more knowledge.
No, thank you.
Representative Gullett, to your question, we left that information or that sentence in there simply because, as Chairman Hitchens pointed out, with the sharing of the withdrawal information, we're really just trying to improve information sharing between the Department of Education and local school systems. So we just, currently they don't know, the Department of Education wouldn't know what school the child's being pulled from based on current information. So we simply just added that in there, thinking it wouldn't be an onerous additional piece of information to include.
Okay, thank you.
Yes.
Thank you, Representative Gullett. 2. Who is 2? Chairman Administration.
Thank you, Madam Chair. I want to kind of jump to what I view as really the operative language here in Section 3, if that would be all right. And
Sure.
if I could ask Director Rollins to kind of jump in as I just read this here, maybe for the benefit of some who are in the audience, they haven't seen the substitute. But it looks like the operative language here really is the first part in line 71. If a child is withdrawn from school and the school employees have any reason to suspect neglect, then the mandatory reporter statute would kick in. Is that a fair kind of summary of what's included there?
We probably ought to introduce the director.
Director Rawlings, would you please
Yeah.
introduce yourself to the
Good
committee?
afternoon, everybody. I'm Tom Rollins, Director of the Division of Family and Children's Services. With Colonel Hitchens' approval, I'll say yes, that's correct. So,
Okay.
and to kind of remember the process, if under this bill, the declaration is filed at the state level, the state, knowing the school from which the child was removed, sends the declaration to the local school. That way, the local school officials, if they have a reasonable ground to believe that this child is being neglected, then they can make that mandated report. And I think you probably were going to go into 76 or...
Yeah, that's right, but I have a question about that in a minute. We'll come back to it. So then 76 to 79 is if the child is just withdrawn, or rather just stops attending school with no explanation as to where the child is, then the department could conduct an investigation. Is that right?
Yes, sir, and the department should.
Right.
If children disappear off our radar screen and nobody knows what happened to them and the parent hasn't complied, we don't know what's happened. We need to go look for that child.
The child just vanishes, just disappears, then you would want to look into that to see where the child is.
Absolutely.
All right, so that's the second half. So then going back to the first half, I see that it's just neglect is the standard in here, but really, isn't it true that under the mandatory reporter statute, if there's any signs of abuse or neglect that causes concern, a teacher as a mandatory reporter under existing law already has a duty to make such a report?
Yes, sir, that is correct.
All right. So, so to the sponsor, in light of that, knowing that that's already existing law, does that, does that make you feel any better about the fact that that's on the books currently, that if there are signs of abuse and neglect already, even if a withdrawal is the tipping point, that would be a basis to not only report it, but under existing law, you would be required to report it. Is that fair, Director?
Yes, sir, and I think the key here is that the tipping point or the decision point, as you note, is that because the school has reason to check into the situation because the child is being withdrawn, that gives them a point in time at which to say, we believe this child is being neglected or abused. Our duty to report kicks in. And so it is really making sure that the local school system knows what is happening, and if that knowledge is such that it causes a teacher, counselor, school principal to say, I believe this child is being neglected or abused, then it kind of gives them the incentive and the opportunity, really, the opportunity to report.
One final question, if that's all right. Could we achieve the same objective through educating teachers to ensure that when they are seeing the warning signs, that they understand what their obligations are under existing state law so that they're able to then follow through with it and make such a report?
Chairman, I think that education is always very helpful. I will simply say that in my experience, if you have a child in front of you in the school system and you know something is going on, then you see that child in your report. The dilemma occurs, I believe, when the child suddenly leaves your school system and you don't know why.
Thank you, Director. Representative?
Thank you, Madam Chair. I guess to follow up on that question, in Section 5, it's saying, I guess, if someone leaves, they report it to the local school system. The local school then says if there's any involvement with defects previously, they have to make another mandated reporting. So if they've already made that mandated reporting, why would they have to, I guess, do it again? Because basically we're duplicating it. So we've had an incident with defects. I was mandated reported within 24 hours. Now, just because the child leaves school, you're going to make me mandate report again, and if I don't, I go to jail. I mean, because that's what happens now. You go to jail if they don't report it. So what's the response to that, I guess? Is this a second mandating reporting requirement?
I'll leave it to the director, but I don't know anybody that goes to jail for not reporting.
We had 2 in Cobb County.
Yeah.
Director?
Yeah.
Representative Wilkerson, I think that the way I would look at this is that oftentimes the decision to report a case of remember the statute is you're required to report when you have a good faith basis for believing a child is being abused or neglected. Sometimes that reasonable basis occurs because the child has because you know the child has previously been involved with defects. Mm-hmm. And I will say that I know of situations from days when I was a judge in which, and in fact since then, in that last 19 years, in which parents threatened or did remove a child from school, withdraw the child from school. These, of course, are not, they may have said they were doing it to homeschool, but the truth is they did it because they believed that the school had called in a report to defects on them, and they were mad at the school system. And so the very fact that there have been prior reports made to defects, when a child is withdrawn to homeschool and there are lots of really bad, questionable circumstances around the parenting, that act itself may give rise to another need to report, because defects may have been involved with the child earlier, with the family earlier. They may have thought they did their work. Our folks may have done all they could, closed the case, and then the family then says, we don't want this to happen again. We don't want to have scrutiny upon us. We want to be able to go back to abusing or neglecting our child. So we're going to withdraw them from the people who reported the abuse or neglect in the first place.
And follow-up question. So,
sure.
But in this case, that school system is already required to report any abuse based on what they see. So just because someone decides to withdraw to homeschool doesn't necessarily mean there is a new case. It's just that there's been in the past, DFACS has reported it. Within 5 days, they got back to the school system, said this has been not substantiated or not substantiated, and let them know that. But now this family has moved on, and they are now homeschooling. And I guess my concern would be that that just because they decide to homeschool, that we now make another report to DFACS and put them in the system just based on the fact that something happened years ago. And if I don't, then I risk being in trouble as a mandated reporter.
Well, I still think we have to go along with the overall context. So in the event that the attendance, the disciplinary record, the observations from the child's teachers, the school personnel, or prior involvement with law enforcement, or, for example, family violence, or DFACS, present evidence of neglect or abuse, really. So it still goes back to the teacher has to have a good faith basis for believing at the time the report is made that the child is being abused or neglected. Now, I will say that our agency has, over the years, assessed situations, received complaints. Sometimes they are from people who are just concerned, but without merit. Mm-hmm. And that one issue, that one prior report doesn't trigger the fact that you need to report simply because the child is being withdrawn. It is that totality of the circumstances that would cause a reasonable teacher to say, I think this child is being abused or neglected, and really the withdrawal of a child from school is the straw that is breaking the camel's back on my concerns.
Okay, and I'm sorry, last question on this. On lines 76 through 79, Madam Chair, so we have a high transiency rate in our area, and which contributes to, our CCPI and so we can't track children. So I guess what this is saying is if we cannot track where that child goes to another school, then now we have to report that family to DFACS?
My understanding, and I'm not the educational specialist here, but my understanding is that generally what happens is that if a child transfers schools, for example, moves to a new neighborhood, there's going to be, within a reasonable amount of time, a request for that child's transcript from the old school. What we are looking at here is the situation in which the child simply disappears from school. The teacher says, "Where did little Sally go?" And so everybody says, "I don't know." And they start looking into it, and they realize that little Sally has not been in school for weeks. They've sent out letters to mama and daddy or guardian. They haven't gotten any response. Literally, the child has dropped off the map. Okay. And then you say, at some point, it gives you cause to say, look, this child, it seems to be missing from society.
Yeah, I would just love to see us follow up with the Department of Education to see how common that is. It's a very common occurrence. I know in my area we have an extremely high transiency rate, and we're actually looking at the impact on graduation rates. So I would just hate to see a family, because they're chasing a cheaper rent in another state or a job, that they are now in DFAC. So I would just love to see the Department of Ed.
Madam Chair, I can kind of speak to that a little bit.
Thank you.
I asked the Department of Education to be here, and they actually had another committee hearing. They had to appear before. But we spoke to, for an example, Screven County's superintendent of schools, and in the case where a child just drops off the face of the earth, it seems, what they do is obviously there's the longitudinal database system that they track children with. If, for example, the child moves from Screven County down to Savannah and starts going to school in Savannah, they will wait a period of time. I think Savannah starts like 3 weeks after Screven County. And if that child appears in the LDS system, after 3 weeks, and it shows that they've moved to a different school, that it's that they know where that child went. Mm-hmm. But if it's a very long time and they just have no idea what happened, there's no formal withdrawal papers or anything like that. That's kind of what this section is getting at.
Okay.
Thank you, Calder. Ms. Thomas, Representative Thomas.
Thank you, Chairwoman. So a lot of my questions were embodied in Representative Wilkerson's questions, but because I really just, before it even comes up for a vote or anything like that, I really just want to I want to know some solid numbers. I'm looking at different pieces, but, I understand the neglect part. I understand the kids going into DFACS. I was a foster kid, and we want to be able to prevent those types of things, and I understand that. But I also was a homeschool kid. So I'm trying to figure out, with it being so many great things that homeschool offers, I want to know, what are the numbers on this? Like, are we really seeing a lot of kids drop off the map and then we find out that they're neglected? Like, are we bringing... is this a solution to a problem that we're seeing a lot? Because I just want to see the numbers, and that's how I will feel more comfortable with saying, okay, this is a really good bill. But I don't know if I came in late and you all had a lot of numbers saying that this happens all the time, but from what I've been reading before I got here, I didn't see that this is something that occurs all the time to where we need something like this.
And the director probably knows better than me, but when I got into this, I started looking around the country and I don't have numbers, but there have been a lot of research done in Connecticut, Kentucky, 2 or 3 other states, where something like this kicked off a research, usually a 2 or 3 year study about what happens in this situation, and in every case, they've changed some of the homeschooling rules because of it, but, you know, I don't have numbers from Georgia. I would hope that the director would have some, Department of Education certainly would.
So let me distinguish between, so, you know, and let me clarify something. My folks always give me data, and I'm looking at a piece of data here that I don't agree with, and I'm gonna read it to you, so I can, especially for the benefit of these nice folks out here who all homeschool. And for the record, I homeschooled my son 1 year, and we lived in Guatemala, and it was too much work for me and my wife. From 2000 to 2017, at least 320 homeschool children nationally were severely neglected and abused. I don't agree with that. I believe that there were 320 children who were not enrolled in a public or private institution of school who were abused. I don't believe those children were being homeschooled. Okay. That being said, the ones we are worried about are the children like Imani Moss, like the Crocker children, like there was a boy in Jonesboro, his name I can't remember, and I saw this when down in Burke County and Candler County when I was on the bench. Children whose parents responded to concerns of truancy, of abuse, of neglect, of the child not coming to school properly clothed, of the child being hungry at school, parents or guardians who responded to those situations, not by saying to the school, thank you for protecting my child, we really do need help, but by withdrawing that child, not to homeschool, but withdrawing that child from school in a false, frankly, allegation that they were going to homeschool the child. And so I think Colonel Hitchens, when he said, the very first thing he said was, this is not a homeschool bill. He's right. We need people to be able to homeschool their children. We also need to be able to have somewhat of be able to check with a local school system if those counselors and teachers say that child was withdrawn or for homeschooling or disappeared off the map, but we really don't think that's what happened. We think there's something wrong here and that child needs to be protected.
So I do remember the Imani Moss case, and I rest in peace to Imani Moss, and I think that was definitely a peculiar case, and we don't want anything like that to happen to any of our students. But I also believe that, just like Representative Wilkerson said, that I mean, in my thought process, I thought that procedures like this were already in place. For example, if a child is truant, frequently a truant caught child, that we have truancy officers in place, and we know that if they are withdrawn right after that, I mean, it's an automatic, okay, this is something we need to look into. I mean, are there are processes in place already to where if a kid is truant or if a kid is reported as neglected already and then they are withdrawn, they're not a procedure?
No, ma'am. And that is the very issue we're addressing with this law.
Okay.
When I met with the drafters and folks who are concerned about this is the problem. There was no trigger so that we could go back and say, look, is this child being withdrawn from school under questionable circumstances? And I think, again, part of it is that when the child is not in front of you in school anymore, the teacher doesn't necessarily know what happened, but at the same time doesn't have any information to indicate that something bad may be going on. When the public school at which the child was enrolled receives the notice from the Department of Education that the child has been withdrawn, that at least is a reminder, a tickler, a trigger for that counselor or that teacher to say, I'm not sure about this. Can we please ask the Division of Family and Children's Services to look into it? And that's what we'll do.
Okay, one quick one. I'm sorry, my board has lit
No,
up.
I understand, and I know we have a lot of
trying to
public
get around
comment. I
everybody.
know we have a lot of public comment. So, can you just, I mean, in like 1-2 minutes, what does that investigation look like? So, if it was to happen, and you are okay, someone was undocumented and left school, would you just go to the house and check on them, or aren't like you said in the DFAC system? How does that work?
Yeah, so we get 150,000 calls, for example, a year. We try to intrude. The state does not need to be intruding in every family's life, so we try to tier those responses. If we had a situation like this where we didn't necessarily have some history of concerns ourselves, we would probably open what we call a family support case. We go out, we talk to the family. We say, is everything all right? Children doing okay? We talk to the children, say, how's everything? We do a sort of what I call a brief intervention. And that way we can do an assessment of the family's situation. Obviously, if we have a situation in which we had more substantial prior involvement, then we might see whether or not the present situation is a problem. But it still remains the fact that we open a real thorough investigation only when we believe the child is in imminent risk of harm. And for lesser cases, we attempt to offer the family services and work with the family.
Okay. Thank you, Representative. Chairman Welch.
Thank you, Madam Chair. Director Rollins, a question for you. How would this procedure have altered or changed the case and outcome in Effingham County?
Hindsight is 20/20, Chairman Welch, but I believe that had we, because of our prior involvement with this family, we had thought that we had successfully worked a family preservation plan with these parents. At that time, the father and the stepmother were living apparently not with this step-grandmother. We thought we'd done decent work. If we had gotten this particular call to say these children had been withdrawn from school, in fact, I'm not even sure these folks, this may have been a 76 through 79 where they just kind of nothing was actually filed. But if they had, let's assume they had filed what they're supposed to do and it had gone to the local Effingham County schools, I understand that there are probably counselors at that schools who would have called DFACS right then, okay, because they would have said, I don't know about this. Number two, if we had gotten the call from the school, we could have at least gone out to the house. We would have seen that they had again moved back in with some other family members that had a history of violent activity. And so can we say this would have changed the situation? No. But I would sure as heck feel a lot better if I had had that opportunity and that tool to say, Aunt, we've been working with this family. We know that they don't do well alone. We know that we have in the past been able to rely on the nice Effingham teachers and counselors to tell us what's going on in that family. And now with these children out of the school system, we need to go out and look at it. So I think it would have made a difference.
So there was no, so then that indicates to me that there was really not a follow-up. A plan was put in place, but there wasn't a follow-up check on that plan.
No, sir. When we closed that case in early 2013, we did not have any further involvement with that family. Now, I will say, we had a call in March of 2017, and we, if we had responded to that call, which was not one of the children not being in school, it was of a historical situation in which another child had seen a child being beat. If we'd responded to that, that could have changed the situation too. But the more opportunities we have to trigger and to allow the protective people, protective adults who watch children, the more opportunity we give them to let us know what's going on, the more opportunity we have to save children.
Okay. And you said earlier that you do a thorough investigation only when imminent harm is believed to be to be warranted or be believed to be observed. In this bill, however, on line 79, we are requiring that DFACs conduct a thorough investigation. That seems to me that we are presuming in the statute that imminent harm is known. Yet the only indications the statute requires is that documentation hasn't been provided or there's been an extended period of time. That seems to me, based upon your testimony earlier, to be more than what we should be presuming in the legislation, and thus a thorough investigation would make presumptions we shouldn't make. So to that extent, that I think that language, a thorough investigation, should not be in this bill. The other questions I had were, what documentation are we referring to, and is not an extended period of time too late?
Just a moment. Let me pull this back up.
77.
So, to answer your first question, my general counsel has raised the issue that investigation is, in our agency, a term of art. Mm-hmm. And I think that at some point we're considering maybe changing it to thorough assessment, because we always do an assessment. And I think your second question was extended period of time. I think Calder mentioned earlier about the fact that normally within about 3 weeks they know something about the child's situation in school. I do think that is one of those situations in which you have to leave the school some discretion. It is not precisely defined, but I think it gives guidance. But I certainly respect your observation there.
What is the documentation that we're referring to?
Documentation?
Yeah.
In terms of sorry, you talking about in the 70?
Well, it's a triggering event both in line 69 and in 76.
Okay. Yes, I'm so sorry.
Yeah.
So with documentation means with the notice, the declaration of intent to homeschool filed. In that situation, the State Department of Education notifies the local school system, which simply asks its local school officials, is there something here that you think this is a trigger that this child may be in danger? In B, in line 76, that means in case the child is withdrawn from school without any notice of intent to homeschool being filed. In other words, if the child just simply disappears from the school system.
Okay, so just for clarification in terms of the administration, if this bill were to move on, is there a reference that we can provide to say that with documentation as required by code section such and such?
Yes, sir. That would be as required by OCGA section 20-2-690 C1. Which is the declaration of intent to homeschool.
Okay. And then, Madam Chair, may I add one more question?
Sure.
The other question I have is, it's more of a confirmation. The way I'm reading this bill is that if a child is withdrawn for the very beneficial and well-intended purposes of homeschooling, the parents will make the declaration of intent. And then under this bill, though, that would then, so if it's with documentation, then that would trigger the school system to then examine the records, attendance records, disciplinary records, and then any observations from teachers, right?
Chairman Welch, it's not, they don't have to do so. My understanding and belief in working with teachers for all these years is that every teacher, every counselor in the school pretty much knows his or her children.
Okay.
So if they get the notice and it causes them to say we need to look further, then they may do that. But it does not require an assessment of every child's record, I don't believe. So.
Yeah, but see, I read it exactly the opposite.
Okay, yes, sir.
And that's exactly why I'm asking the question,
Okay.
because I read this, if I'm going to advise a school system,
And which
I do,
yes, sir.
then I'm going to read this bill and I'm going to say, if someone serves notice of intent, then central office and principals down the line, you're required to do, and you will have to do a look back to see if there's anything in the records of this child and any observations made by the teachers or personnel that at the time you did not perceive would justify mandatory reporting. Mm-hmm. But now in the totality of all of these circumstances, do we now, retrospectively, looking back, do we now have to say, wait a minute, we now have to report? And that's and that creates a heavy burden on the school systems to do, because I don't read this as optional. I read this as, if notice is issued, then I've got to do something, because I can't satisfy the next sentence. Mm-hmm. As a school system, I can't satisfy the next sentence if I don't do a look back.
Yes.
The way this is written, and I think that's what we're doing is we're effectively going back to Representative Wilkinson's statements earlier. We're in fact, by this measure, and I know I'm going to pause for just a second. Chairman Hitchens, I know you know that I'm coming from a very sincere point of view. Sure. I appreciate fully what you're trying to accomplish in terms of protection. But I think it's our duty to look at these things and see what the scope is. And I know you know that, and I just want other people to know that my questioning is not to dismantle or derail the bill. It is simply to do the job that I think we have to do, which is ask these questions. But I think what it does is it places, the effect of this is to place the school system in the position of being of effectively being a second arm of DFACS. Mm-hmm. Not where they have to do it when they see it, report it, right? But then this becomes a second look, mm-hmm. so that when a notice is done, which we presume we hope will always be in the best interest of the child for true homeschool education purposes, but in the event that evil people do evil things, mm-hmm. and take full advantage of a systematic loophole, and it's just not a loophole. It is an opportunity that the law affords for good parents to be good parents and to educate their children at home. Someone evil can take advantage of any part of our system and abuse it. Right. And so what we're asked, practically what we're saying, school system, you have to pause, stop what you're doing in educating children, and go back and check these records, and then say again, does this then trigger a response that we need to now report under 19.7-5? I think that practically is what happens with this language. I think that is how school systems are going to react. And I think I don't think they have a choice. I mean, I think that you'd rather react this way, right? And be as conservative in terms of reading this legislation as possible, because you don't want the flashback of not having done that, right? It's shifting what happened in DFACS' situation now to a school system, and having to deal with that potential liability and negative publicity. And I am gravely concerned about that. So I just wanted to express that in the form of the question, because that's how I read it. And I know you may read it differently, but that's how I read it.
And I appreciate that, Chairman, which I obviously would defer to Calder and the author, Chairman Hitchens, on those issues. I just want to say personally, I appreciate that viewpoint. I had not, and especially with your background in education law. So.
I'm very cognizant of that, and I've always appreciated your legal intellect, and you know, I guess that's why we're all here, is the process, and that's we want to do it the right way so that there are no unintended consequences as we go down the road, and whether this is passed or not. It's,
Yes, sir. I know you do, and I know you feel for the lost lives of those children, and any children that whereby someone, an evildoer, would take advantage of our system, whether it be through this mechanism or some other mechanism to abuse children. I know that is in your heart. You want to stop that at every juncture you could possibly do. I believe that to be true.
Sorry, I turned myself off. Chairman Cantrell.
Thank you, Madam Chair. I do not claim to have any legal expertise here, but I think I have some practical. And I appreciate what you do, Director Rollins, very much. I know it's an extremely difficult job. My concern is that it feels to me like we've lowered the threshold here, kind of piggybacking on what Chairman Welch has been talking about. But on line 72, I've got a real concern with that one word there that just says "or," because it makes it sound like this is a family who had there were no prior concerns about this family. My understanding of the intent of this bill is to flag a family for which there was a prior concern. So I'm wondering if we could fix this simply by changing that "or" to an "and," meaning that family would have to have an open file with either DFACS or law enforcement, because I think you are setting up a trigger mechanism for a family withdrawing from school and then all of a sudden making the school look back and wonder. And I think that's to Chairman Welch's point. So I think if you put an "and" there so that this family would have to have been previously flagged prior to withdrawing from school, I would have a lot more comfort with this than I do currently, because I feel like you're putting some families under scrutiny that do not deserve it, and then you're asking school personnel to kind of think back and go, oh, wait a minute, okay, they withdrew from school. I wonder why. You know, oh wait, yeah, dude, and they start to reconstruct some thoughts in their mind that they might have not previously been concerned about. Is that, you follow me?
Absolutely. Yes, sir.
Do you share that same concern?
I think anything we can do, Chairman Cantrell, to strengthen this bill and to get this thing to the point where we can make sure the children aren't being withdrawn for that bad reason is what I personally not want to get to.
Fair enough. Thank you.
Yeah.
Thank you, Chairman Cantrell. Chairman Clark.
Thank you, Chairman. I have just a concern with the bill. I know, Chairman Hitchens, that you're coming with a passion and a heart for these two kids that were killed, and no, it affects all of us. Just reading it and watching it in the news. My struggle is I'm just wondering if we pass this, is how does it fix what happened to these two kids, and would it have saved them? And I can't see where that would have. And I guess the second one is just, I struggle to understand how this bill, if DFACT had a case, and it seems like they could have failed the kids, and if we overload the system with this reporting, how does that fix the problem? I feel like, this is maybe I feel good, and we're trying to do something good, but it's just going to overload DFACT even more.
Well, I think it'd certainly be work intensive, and we've tried over the last couple of years to add DFACT workers, to fund them, to pay them more. I've dealt with them on many occasions. They have a pretty significant turnover. It's not a good job. You deal with people in all kinds of situations. You go in, you see children that have been abused, neglected. Many of them end up buying them clothes, buying them food, and you see the underside of life, which these people have gone to college and they want to do the right thing. And I've dealt with several of them who just left early because it is a tough job. But my perspective is, if we save one child, and as I've gone through this, as I told you, I've done some research, and they've they've done research in other states, and every time it's something similar to this. Some child gets killed, or some child is brutally abused in some fashion that instigates it. And I don't believe it's it's significant in terms of numbers, but if it's you, it's pretty significant. If you have parents that abuse you and mistreat you, and if y'all read this article today, and that's certainly a very unusual case, but you know, I just have empathy for children. We all believe that our parents are those people that take care of us. They protect us to the end. I mean, I got 50-year-old children, and I still am very protective of them. But if you have a parent, and if you read this thing about the things they did to those children, I mean, and nobody interceded. Neighbors saw it. Neighbors got on TV and said, you know, I saw some things, and my God, I wish I'd have told somebody, but I thought it was a personal family matter, and I shouldn't get involved. And this won't catch everyone, but you know, in a criminal enterprise, you never catch everybody all the time. And the one thing they all do is they try to hide behind some type of cloak of anonymity, which saying that you're pulling your child out of school to do something else that's legal. My guess is very, very few of the people that abuse children that actually pull them out of school under the guise of homeschooling actually teach them much. They were keeping these kids in cages, and you know, their arms were so they became so stiff that they couldn't move, and when they took them out, they used duct tape to tape them to the walls so they could straighten their arms out. And they put things in their food that made it so horrible that they couldn't eat it. They were about to die of malnutrition, and certainly somebody should have seen that. So.
Thank you, Chairman Clark. Representative Oliver.
Thank you, Madam Chair. I'm thinking about Representative Cantrell's, is he still here? Okay. Suggestion of putting an and instead of an or on line 72, and eliminating, I'm also thinking of a suggestion, and I asked Commissioner Rollins and perhaps Representative Kitchens for the idea of just eliminating the language of child's prior attendance, disciplinary action, observation from the child's teacher or personnel, and saying simply in the event that any prior involvement of the family with law enforcement relative to issues of neglect. It shouldn't be a prior involvement of law enforcement if it's bank fraud or bad checks or something like that.
No.
The law enforcement involvement or defects involved has to be specifically related to, and I would say abuse or neglect there. It seems to me that tightens it a good bit. The real issue is whether or not it's an open case or a closed case. I think in an open case where a child is already in a family placement or there is some ongoing investigation, then defects is going to know if the child's withdrawn from school.
That's right.
So it really is the issue of to what extent a school has to be thinking about a prior case. I don't have specific numbers of how many of the 200 children are killed a year by adults, how many have an overlay of alleged homeschooling, and I agree it doesn't have anything to do with homeschooling, it has to do with criminal activities in the area of neglect and abuse, what the percentage is, but I know that it's in my law practice and in my political life around abuse and neglect that the opportunity for a family to isolate a child away from the usual societal professionals looking at that child is used repeatedly in my professional experience and political experience. So the teachers are our biggest reporters of alleged abuse now. They have a very hard job to do that, very hard, and I'm inclined with tightening language here to be more focused on prior involvement in that possible prior case. I think that is where our most likely harm to a child.
And I don't think you were here Representative, but
Forgive me for being
I
late.
said at the beginning that I'm open to anything. All I want to do is try and make the situation better and to try and protect children who aren't protected.
So Representative Cantrell is back here. I was commenting on I'm thinking positively about your amendment and going a little bit further.
Thank you, Representative Oliver. Representative Gullett.
Thank you, Madam Chair. Prior involvement of the Family of Law Enforcement Division of Family Services or DFACS, is the school, I'm not familiar, I don't have children, so I'm speaking at this blindly a little bit. When there is law enforcement or DFACS is involved in a child, is the school made aware of that today? Because we make it an and I agree with Chairman Cantrell on the and piece there, but I'm not familiar with whether a school would know if DFACS was involved or if law enforcement had been called, to the home about an incident.
Not necessarily. I think that's a good point. So if we have, obviously, if a child is in foster care, then the school is going to be notified.
Okay.
And oftentimes our investigators will go out and speak to the counselors because, frankly, we get a lot of our referrals from school people.
Right.
So they might know that way, but there's no consistency. I may have some language if y'all want to have a suggestion that was in something earlier bill that may help. And
Okay. Well, I tell you what, Chairman Hitchens, with your acquiescence, if y'all would like to kind of rally around, I think you've kind of gotten the temperature of the committee. I know there are several members of the public who have signed up to speak. So if y'all would like to perhaps work at a table or an adjoining office or kind of circle up, you're certainly free to do that while the committee hears from. And also committee members, if you would like to email or text or kind of circle up with Chairman Hitchens and Calder and Director Rawlings while we are hearing from the public, that will be perfectly fine. Majority Leader Burns.
Madam, excuse me, Madam Chair, would it be out of line if I asked to make a brief statement?
Sure.
And would you like me to go down in front of me? I'll stay here.
You can stay there.
I won't take much of the committee's time, and I appreciate what the committee is doing, and you are doing exactly what we expect our committees to do, and that's certainly help perfect legislation. But I want to say this. For me, this bill is not about homeschooling per se. I have great admiration for folks that are here today and the folks across this state who homeschool their children. They're doing excellent work. This bill also, to me, is not about government interfering in the private lives of law-abiding Georgians. This bill, to me, is about protecting the least among us. And yes, I'm from Effingham County, along with Chairman Hitchens. Children, I believe, in many cases, have no one else to love them or fight for them, but for us. These children we've talked about it in the paper, that suffered so severely, were the victims of circumstances, of parents whose sole purpose was seek to abuse those children and evade the detection of child abuse and neglect that was available to them in our schools and through our state agencies. Now, I also think there's a lot of misinformation going around about what y'all have been talking about the last few minutes when I was not here. But I want to be clear about how I see this measure and what my purpose is here. The only people I feel that should fear this legislation are those evil enough to harm a child, not our homeschool parents. And also, I'm not looking to place blame on anyone in this scenario. I'm simply looking for solutions, working with DFACS, working with our local school system, and working with parents. And again, we're doing what we should be doing. This bill is not perfect by any stretch that we've initially presented. But I always believe we should never let the perfect be the enemy of the good. Because this bill saves one child's life, we will have done our job. And I look forward to working with the work of this committee. Hopefully we can move something forward that will be beneficial to all. Thank you, Madam Chairman, for indulging.
Thank you, Leader Burns. And I know the late, great Chairman Golick often said, let us not let perfection get in the way of progress. So I certainly understand that and understand that it is a work. So at this time, we're going to start with public comments. We have quite a few people that are signed up to speak. I will let you know if you're here on 5:30. 5:30 is the first thing that we're dealing with. And just so you know, we do have a couple of other items on the agenda, so we do need to kind of move things along. It is now after 4. So we are kind of wanting to move things along. So I will limit individual public comments to 2 minutes per person. And the first person signed up to speak is Mary Beth Morris on House Bill 530. Ms. Morris? Okay. I do apologize. If you could kind of wheel around, that table mic can move. Well, if somebody could take somebody will bring you the microphone. You can come up front and kind of, we can put the mic there. Thank you, ma'am. Welcome to Juvenile Justice Committee hearing.
Thank you. Oh, so sorry. Hey there, folks. I'm here to speak to you. My name is Mary Beth Morris. I'm here to speak to you today on behalf of Georgia homeschoolers. My husband and I, who's with me, represent Georgia Home Education Association. We are pretty in tune with approximately 60,000 students who are homeschooled here in Georgia. Want to let you know, someone asked how frequent is it that these kinds of horrible things happen. I can remind you that we're celebrating the 35th anniversary this year of the legalization of homeschooling here in Georgia. So, you know, the folks that are represented here are part of a 35-year history. And I think we've heard several times that this was a strange anomaly of a case. Horrible, horrible, unconscionable. We in no way condone child abuse, but we don't want to have a knee-jerk reaction and bad policy as a situation, you know, as a result of a situation that was just, you know, we don't want to see policy developed out of
we don't want to govern by anecdote.
Right. And we don't want to see innocent people hurt or prevented or obstructed from homeschooling as a result. The folks here today, I don't know if our Savannah representatives are still with us. We have over 100 representatives from the Savannah districts combined that are here as part of our Homeschool Day at the Capitol that we celebrate every year. On an annual basis, we've got over 1,000 Georgia homeschoolers representing about 60% of the House districts, and I think we're up to way north of 90% of the Senate districts. So we're here from across the state. And obviously you can see by the response, homeschoolers care deeply about this situation. As to, some of you had asked about research. We passed out, before we left the other room, there's a 3-page handout that the committee was shared with the committee.
Yes, ma'am.
That does have research statistics and that sort of thing. It also addresses some of the things that have been discussed and some of the questions that have been asked in terms of statistics and that sort of thing. So I want to point you to that resource. Some highlights from that research is that actual research and facts have been found that homeschool parents are no more likely to abuse their children than anyone else. So that's important to know. There was also a study done by the federal government. It was reported out in 2016. It was the Commission for Child Abuse and Neglect Fatalities, because the federal government felt that there were too many fatalities due to this going on. They looked into it, they studied it for 2 years, and their finding was that homeschooling was never brought up as a trigger or as a root cause. However,
ma'am, you're like 3 minutes over.
I'm so sorry.
So if we could just kind of, I have a lot of.
Okay. Bottom line, we feel like asking the withdrawal should, because of the situation that already exists. Law currently requires teachers and school officials to be mandated reporters. The withdrawal to homeschool, we've heard several times that this isn't about homeschooling, yet the documentation that's being mentioned is the Declaration of Intent to Homeschool, which very much makes it a homeschool issue. and they're asking that information on, I think it's line, I haven't seen the substitute bill, but on a previous version it was lines 31, 32, or thereabout, that adds requirements on our annual declaration of intent. That's not a one-time thing, that's an annual declaration that we're required to make. And so those are some of the highlights. Again, we just don't think that the withdrawal of a child to homeschool should be what triggers
Okay. Thank
an
you.
investigation. Thank you. Thank you very much. Appreciate it.
Thank you, Chairman Administration. Oh, sure. If you'll stay, please. Thank you.
Certainly.
Oh, there we go. Sorry.
Thank you, Madam Chair. Thank you for your testimony, Ms. Morris. I want to thank all the individuals who are here today also that you referenced. I remember visiting the Capitol when I was a young person for a bill that I was interested in, and it was a great experience. I think led me to where I am today. So it was
Part of home education going on.
well, I provided you with a copy of that because that's really what we're talking about here today is this bill, right? Just getting, and you haven't seen the substitute, I know. But if we really get to the operative language, you said that really this is about, you mentioned a moment ago what teachers already are required to do. That's the mandatory reporter stuff that we were discussing before. Is that right?
Yes, yes.
Yes, ma'am. And so we're looking lines 71 to 75. That's where we're talking about the withdrawal with the documentation provided. Then in the context of the history, then the school shall make a report. That's what Chairman Welch was talking about. That might be an onerous requirement on the school and all the rest. So I assume that, of course, is where you take issue. Is that right?
Very much so.
Yes, ma'am.
I take issue with several parts. That is probably our biggest issue, yes.
Okay.
And we can certainly understand that onerous burden on the schools. And because of that, we feel like it would create a position where usually, for some reason, when someone withdraws a child from a public school, probably to homeschool, there's already some level of dissatisfied customer going on.
I understand completely. And we don't want the school to maybe be upset and use this as a means to then cause a problem for the family.
Yeah, a pre-existing conflict.
And I'm sorry, it's just, I know everybody's been sitting a while, so I'm kind of getting to where I'm headed with this. So that sentence, of course, is an issue. But as far as if the paperwork is submitted to the central office, so the sentence before that, just that the school is notified, I assume that you don't have a problem with just the school being notified that the paperwork has been submitted, that the child will then be homeschooled.
The central office, well, I've not withdrawn a child from school, so I don't know what the practical, I mean, I don't know that's most of the people that we talk to are withdrawing from the local school, not from the central office.
And they're following the rules, exactly. So we're talking about a very specific, very unique, probably, circumstance here. If we go down to the B, which is below, so 76 to 79, this is where there's no paperwork submitted. The child is just, you heard the director earlier, the child just vanishes or is gone. And after reasonable time, do you, I don't know, do you have any objection to a referral under those circumstances being made if the child hasn't turned up somewhere else and no paperwork was submitted?
Well,
the child just didn't show up to school.
Right. As a citizen of Georgia, I thought we already had things in the books to cover this situation called truancy. So I absolutely have no.
Actually, it's my understanding, and it's very sketchy because I've kind of had a bit of a trial by fire. But truancy really only kicks in whenever the child over 16. That's whenever the child itself is. Understanding what.
No, the age of compulsory attendance ends at 16.
I have a little experience with this. I used to work in juvenile court, and I'm familiar with truancy cases. And a lot of times it's very difficult to bring those cases, typically. And there would have to be an element where the parent is being compliant and the child not attending school and such. And so I guess really I'm trying to kind of isolate the point of disagreement, if possible, for us right now. I was thinking that it might be that when the paperwork had been submitted to the central office, and then that's effectively used as a basis possibly to then seek a referral to DFACS, that is really the heart of the issue here today. Is that fair?
The central office of the local school system, are we talking about the state office where we file our declaration of intent? Are we talking about a district office? I'm confused.
Well, I
at
was
the
assuming it
term.
was district, but I heard state before. I guess the point is it's not the school.
Point is, it's ambiguous.
Right.
Right.
Well,
That's-
okay. Well, that's really what I'm getting at here, though.
Right.
The issue is, though, if that has occurred, the paperwork wasn't submitted to the school, and then a basis based upon the history is used to then seek this referral. That's the heart of the issue you take with it.
Okay.
Is that correct?
Homeschool law requires the family, the parents, to submit a declaration of intent to the state office. So, may I bring someone else?
Oh, absolutely.
Who can
I'll
probably better
I'll just
parse
suspend
this
and
because
maybe
this is
I'll,
different language.
I'll hear
than-
from other witnesses. So thank you very much.
Okay, thank
We
you.
do have 16 other witnesses who might be
Okay.
able to address that.
Great.
And I will, because we do have other bills and other issues that this committee is very invested in, to hear, we will, I will try to be a little more stern whenever it comes to that 2-minute limit. Mr. Stone, if you'll come forward. And if you would, the podium, please. Thank you.
Madam Chairman, my name is Joe Stone, and I'm also with the Georgia Home Education Association. The idea that this is not a homeschool bill, and I mean no disrespect, but it's ludicrous. I mean, if the documentation is the declaration of intent, this is a homeschool bill. Okay, if the declaration of intent triggers this investigation because somebody simply withdrew from school, then you are putting an onerous burden on the citizens of Georgia to homeschool their children. Now, I agree with Representative Welch. The unintended consequences to the school are going to be just as he says. But the unintended consequences of the citizens of Georgia who try to simply withdraw from school and have got some sort of any kind of bad blood with that school are subject to an investigation for no reason whatsoever other than the fact that they have ticked off somebody at the local school system. Now, to answer your question, the way I read it is that we file our form of intent, our declaration of intent with the state office, and then the state office turns around and sends it to the local county Board of Education. That's the way I understand it. And as far as that's concerned, I have no problem with that, and I think that they could probably legally do that now. I think they could. Now, very quickly, I want to respect your time. Paragraph B, where a student withdraws without documentation, I think that's completely unnecessary. That's a violation of the law. I have prosecuted people for that. So I don't even know why that's there.
Okay.
That is about the 6th unexcused absence is a violation of the law in Georgia. And so you can be prosecuted for it. So that's unnecessary.
Okay.
Okay.
All right. You have a question. Oh, you no longer have a question. Thank you, sir.
Okay. Is my time up?
Oh, it's been up for a good minute.
I'm sorry.
Sorry. I need to be a little meaner. Maybe I'll start kind of ringing a bell or something. I know. Dan Beasley? I have a timer.
Madam, he went outside. He was summoned outside.
Okay, I'll come back. Samantha Mirabal?
I am a homeschool parent who is a part of.
We do have a lot of people watching online, so if you could pull the mic to you so we can all,
Yes, sure.
so they can hear as well. Thank you.
Yep. I'm a homeschool parent, and I'm a part of a large homeschool co-op called Newton County Homeschool Co-op, which kind of combines actually Newton, Henry, and Rockdale counties. My biggest concern is I had my daughter in a Rockdale County school at one point. I'm sorry, no, a Newton County school. And she got mixed up with the wrong crowd. She was in high school, started smoking marijuana, and I needed to intervene. And it was a very difficult decision for both her and I, for me to pull her out and homeschool her. But it was the best decision for her. And I, as the parent, stepped in and made that decision. Now, I can tell you that there were people at the school that disagreed with me, okay? And I, going in there, if I knew I had to face this kind of scrutiny to step up for my daughter and do what I believe is best for her, I may have thought twice about doing it, and she may not have graduated. So I am happy to report that I did do it. And yes, I did get a feeling of there were a lot of people in the school that like, what are you doing? Why are you doing this? You know, it's already hard to do that. But she did graduate. She's been in college for 3 years. Had I not intervened as a parent, who should be the first one, by the way, to decide what's best for our children, where would she be? Would she have graduated? I don't know. So that's
going to be my time up wave.
Okay.
So just so everybody knows, time up wave.
So that's my biggest concern, is that other people who are trying to help their children as parents may be feeling like they're under extra scrutiny and not willing to step in when they should.
Okay, thank you. Thank you. Did you have a question or no? The audience will not comment whenever people are testifying for or against the bill or whatever relative to that testimony. Thank you. Let's see. David Hamilton. Mr. Hamilton? Welcome, Mr. Hamilton. Please introduce yourself to the committee.
Thank you. I'm David Hamilton. I'm a husband, a father, and we homeschool our 2 girls at home. That's what I call it, homeschool. I'm an attorney in Alpharetta, and when I read this bill, it was a little bit of a shock, because as an attorney, and I'm sure everyone up here and a lot of attorneys up there, a lot of great questions about this bill from you guys. I really appreciate the scrutiny on this. The reality is, how on earth could you be at a public school and be an administrator or an official there, learn that someone's been withdrawn and not report? Safety first, right? I mean, who knows? That guy had a scowl on his face when he left here, you know. And if they did it as a spiteful thing, even, they have a defense all day long. There will never be any scrutiny upon them. There will be no liability. It could be abused. And we all know that we don't want to give power to those who could abuse it if possible. It's impossible to fix that all the time. But in this case, homeschool is the documentation that causes the scrutiny, that causes someone to come and then possibly put defects on somebody, come to their home, make the kids feel weird, wonder if mom and dad are committing a crime, what are we doing, why would we be investigated, create stress all over the place for a really awful thing. It's just awful to go through that. I couldn't imagine that happening to me. I think I'm an even keeled guy, but if someone was coming to my house, some clown from wherever, you know, and that's the way a dad would feel, someone's coming to check up on them, I might react in a way that makes them go, we need to check on this guy. You know, I think our girls are thriving homeschooling, and I think most kids do.
Okay.
Thank you for your time.
Thank you. I'm going to make y'all start typing these out. Having a real hard time with some of this handwriting. I believe Bailey, Marion Bailey, Martin Bailey, ringing any bells? I know there's a, what do you think that is? No.
Keaton Brantley?
Keaton Brentley? We really can't read this handwriting. I do apologize. We're just going to move on. Oh, okay. Nope. That was not him. Okay. Oh, okay. Yep. You need to kind of say, hey, that's me, or
Yes, ma'am.
Thank you. All right. Please introduce yourself to the committee.
My name is Keaton Brumley, and there's nothing really special about me. I'm just a homeschooled student. I'm 17 years old, but under the dual enrollment program, I'm able to graduate with my bachelor's degree coming up at the end of this summer semester, and be going on to law school starting in the fall. Without homeschool, I wouldn't be where I am now. You know, homeschool has meant so much to me, and it's made a profound impact in my life. The public school failed me. The private school failed me. The online public school system failed me. They didn't let me move at my pace, at my speed. They gave me more work and told me to dumb it down. This bill means a lot to me because if this bill was put in place at the time my family was considering to homeschool, I probably wouldn't be a homeschooled student. This bill would have deterred my family. 4 of my siblings are adopted. They've been through the DFAC system. When I was pulled out as a homeschooled student, I was the test guinea pig. There's 7 of us, 7 children. Actually 8. 1 is on the way. And I was the test guinea pig, so we were taken out one at a time, really. And what this bill would do is each time one of us was taken out, a DFACS worker would be sent out every time. 7 times my family would have to answer to DFACS. DFACS came to our door, and it traumatized the 4 children who were adopted, and it had them reconsider their loyalties to my parents because they were afraid of DFACS. They were afraid DFACS was going to come and take them away, and this bill just traumatizes us and would have deterred me from moving on to where I am now.
Okay, thank you. I do apologize, y'all. I'm not, I'll have you removed. I do apologize, but I will start being a little bit more stern as far as the timing is concerned, because we have other measures that we need to, apparently the wave isn't, let's see, Mariana Slaughter. Ms. Slaughter, would you like to join? Thank you.
Good afternoon. My name is Mariana Slaughter. I live in Beaufort, Georgia with my husband and my 3 children. As a third-generation public education professional, a teacher, I left the school system before I had children, and I knew that I would not be enrolling my children in the public school system. I think that this bill creates a really undue stress on our schools. They're already spread thin enough at this point, and this bill is just creating more work for them. And frankly, it's in an area that they do not have much knowledge in, and they don't need to be making the decisions on protective services going in or out of a home. Above that, we are, a majority of us, exasperated with the public school system, and this is not something that we need to. I'm sorry, I'm holding my baby. This is not something that we need to have additional grief with our public school system about. It's frankly not their business. As a lot of you have said, and I am very, very grateful that you guys have looked at this bill with a critical eye. This bill is just inviting undue stress on the families and the school systems. So thank you so much. I wasn't able to read the new bill that was produced today because we were touring and speaking with our senator. So I do appreciate the changes that have been made and that will be being made additionally.
Okay. Thank you,
Thanks.
ma'am. Oh, and you were 20 seconds under. Y'all can applaud that. Okay, we have Diane Ullman. Ms. Ullman, welcome, and introduce yourself to the committee.
Thank you for allowing me to speak. My name is Diane Ullman. I am a second-generation homeschooler. I homeschool 4 children of my own, and I just want to say I'm actually from the county where the Crocker children were brutally murdered, and I come up, I want to represent them because children are near and dear to my heart, and so may they rest in peace. But I also want to say this. I want to say I was very, very active in the Effingham homeschool community. There are a lot of us, and we are not all criminals, and I feel sort of like the bill made us out, or made it like if you do homeschool or you want to take your children out of the school system, that it sort of cast an eye upon you, a suspicious eye already. But I also wanted to say this. In the case of the children, I feel like, are we not scrutinizing defects enough? There were many calls already made for those children, and I just feel really bad about that. I've worked as a parapro in the actual school system, and so I know that we have to report if we see something. And that bothered me, that the fact that they would go after homeschooling when, in fact, it wasn't homeschooling at all. What happened to why was the ball dropped by defects? I just wanted to say that. Thank you.
Thank you. I appreciate your sharing. Jennifer Landry. Jennifer Landry. Okay, moving on. Mercedes Barker. Please come forward, Ms. Barker. Introduce yourself to the committee.
Hello, I'm Mercedes Barker from Hampton. I'm a home educator of 4 children for the past 14 years. The biggest thing I want to say is there's problems with this bill here. I'm just going to go sort of down in order. The one thing was, why did they strike out the section about of when they come to look for paperwork that they need a subpoena? No one has even addressed that. On the original bill, I don't have the updated one.
Okay, I do apologize for that. Do we have an extra? Anyone? It's not in the current bill.
I mean, that's a protection we have had from DFACS, anyone coming to the door and saying, we want to see your paperwork. I've been a member of HSLDA for many years, and I know that that is a legal protection I have. Thank you, sir.
Yeah, it's no longer in the bill.
I'm not going to be able to read this fast enough. I'm going to go off of I'll go off of some of my other things. I'd have to look at it.
Okay, sure.
A little more in depth. The other things are, if these children, and I feel really bad, and hearing this as a mother of 4, this is terrible what these people did. But when the children didn't show up to school, where was the truancy officer? Again, we have these things in place. Where was DFACS? It wasn't one time that DFACS was called in. It was 3 different times that DFACS was called in. Why didn't they report it? When those children didn't show up for school any longer, why didn't they show up? That's the real issue.
Okay, thank you, ma'am. Paul Fernalor? I know that's wrong. Paul Fernandez. Welcome. If you'll introduce yourself to the committee.
I'm Paul Fernandez and father of 2 homeschool children. And Wes thought my name was a little too easy to say, right? I think you're seeing a theme. This bill is a duplicate of something that you already have on the books. If there's issues of funding with DFACS, if there's issues of people in the school system breaking the law and not doing the mandatory reporting, I think you'd have something to talk about. But when we see an unnecessary law put forward, we have to question the motives. And the main thing that you start to hear from people who pulled their kids out, and which we didn't, we started homeschooling from the get-go, so we never had to pull our kids out, is doubt. And there's an inherent conflict of interest. Give you a quick example. A friend of ours, she had a child in school, the problem child, always in trouble. Create tension in the home, create tension between the school and the parent, conflict of interest. Because when the mom actually went to school, she found that her child had already, on her own, just with her mom, advanced well beyond what she was being taught. She was flat out bored. That's all it was. And no one was protecting that child from boredom. Mom did. Pulled the child out. Wasn't necessarily a happy time for the school. And they also have another inherent conflict. The conflict is they get paid by the child. So now you're putting more work on people who have an inherent conflict to keep the child in school. It's dollars, but also maybe animosity with the parent making the decision. And you're asking them to do additional reporting on top of reporting they're already required to do. And so if it's unnecessary, we should compromise and kill this bill.
Oh, thank you, sir. Matt Urick, welcome. Introduce yourself to the committee, please.
Hello, Matt Urick. My wife and I have been homeschooling for about 15 years with older children that have gone into the university systems, both here in South Carolina, but here in Georgia as well. And I think that what I wanted to say is the temperature of the representatives and their questions to the bill sponsor represent what 300 plus people came out of their homes to suggest that this bill is hot garbage and that it shouldn't go in its existing form, in its substitute form, or any form therein. It's a difficult situation with the statement or the family that brought this, but the bill was introduced about a week ago, and we don't want to fast track it, or we don't want to move this thing forward without looking at everything. Well, that's exactly what we're doing right now. We got all this opposition. The bill sponsor said he had 20% of 1,500 emails that he received over the weekend, which is 300 emails for this bill in opposition. That should say enough right now that this is certainly not ready to go for this year, and we shouldn't even be considering it. Thank you.
Thank you. Robert Owens, welcome. Introduce yourself to the committee, please.
Hi, my name is Robert Owens. I'm a GHEA volunteer. I'm a registered nurse working in the emergency room for 20 years. Currently, I'm a case manager in the emergency room. And you already have laws in place to find child abuse, child neglect. Those cases are already being reported to the DFACs. And if they do not have a large enough budget, I would ask that you strengthen that to be able to follow these cases. I would be saddened if you were to mention nurses and say we're supposed to report every case that walks out, elopement, AMA, without seeing the doctor before for nurses. I mean, that to me, if I'm not recognizing the signs and the symptoms as a mandatory reporter prior to that, then something is wrong with my practice. If the teachers are not able to have that tool that they need to recognize that and to report it to DFACs prior to, being pulled out of the school, something is wrong. That shouldn't be the stopgap to legislation, and I request that you oppose this bill. Thank you.
Thank you, sir. Appreciate it. Brent Gordor. a homeschool dad named Brent. Is there one here? Sorry, it's a long day. If you would, please stand and introduce yourself to the committee, please. Thank you.
My name is Brent Googe. I'm an anesthesiologist in Whitfield County, and I am a homeschool dad, and usually people go to sleep within 20 or 30 seconds when I start talking. That's my job. Before my wife was a homeschool mom, she was a DFACS worker in Whitfield County. I don't know what they make today. I know that in 1999 they were not paid strongly. I also remember a time that she said somewhere in the state a child within DFACS custody had died, and immediately hypervigilance went up. So I have a hard time imagining one miss by the school system that every child that pulls out to homeschool won't be reported. I have a hard time imagining that the DFACS won't, at that point, just be checking on every single case, every single time. And also, in medical school, I remember working with a geneticist in Chattanooga, and she had a family that had a baby that had a genetic defect. The baby was going to die within 12 months. And they made the family decision that they wanted the baby to die at home. And there were laws in place at the time in their district that every death at home of a child, DFACS had to go investigate. And she was begging DFACS not to go check this out. They said, the baby will die. They're not doing anything wrong. They're great parents. They just want the baby to die at home. But DFACS, I don't know exactly how it ended up, but she was struggling with DFACS at that point, trying to not to get them to investigate. I have a hard time believing that after the first miss by the school system, this won't happen to every single homeschool parent.
Thank you, sir. I appreciate that. Teresa? Shen? Will you introduce yourself to the committee, please? Thank you.
Yes. My name is Teresa Shen. I'm a homeschool parent of 2 children. I want to make 2 points. Number one, let me remind everybody, we are living in a sinful world. A lot of darkness in the world. That's why you see parents abuse their children, killing their children. Lately, I just read their own parents sex trafficking their own daughters in Georgia. Okay, unthinkable. But let's think the other aspect of it. Not all teachers are saints either. Okay, there are some bad teachers, right? Bad administrators. I love the ones I know. They are, in a noble fashion, a profession. They do the best they could. Let's look at statistics. How many? Just Google it. What's the statistics of children being abused in the public school system nationwide? 7 to 10%, 3.5 million to 4 million. Sadly, that trend is going up. Google it, public data, okay? This number, 7 to 10%, from multiple sources. A lot of research being done to this. So let's just say, are we going to put our trust on some individual administrators or teachers? Do we fully trust them, okay? I want to bring that to attention. Ask yourself this question. Number 2, again, I'm adoptive parent. I adopted my daughter when she was 8-year-old from China. When I adopted her, there was no indication on her medical report saying she has any seizures whatsoever. When we found out 2 years later, she has seizures. Okay? In the middle of the night, she will fall on the floor, have bruises on her face. At that time, we had no idea. School, back then she was in the school. School system called me and said, hey, what's going on, right? Luckily, I was the school mom, I was a room mom, I was a volunteer in school. They liked me, they trust me what I said, they trust what the child said. What if I had some friction with them? What will happen to us? What will happen to my family? What happened to my biological son? That's a question I want you to keep in mind. Every parent.
Thank you. Sorry. I'm sorry. We've got 10 other people signed up for on another bill, and we just have to keep going. Denise Mabry.
Madam Chairman and Committee, hi, I'm Dr. Anise Mabry. I have over 20 years in law enforcement.
I have over 20 years as an educator. I'm a retired Dean of Graduate Studies for DeVry University, and I'm also a homeschool mom. I operate the only nonprofit organization in Georgia that works with sex trafficking victims, high school dropouts. I'm partnered with Macon County to provide the Chief's Diploma program. And the only reason I'm able to get women away from their sex traffickers is because of the homeschool laws as they're written. If you change these laws, you are going to leave my most vulnerable population even more vulnerable. So the laws as they're written, you know, what happened was an abnormality. We can't govern an abnormality with a blanket sweep. So I'm asking you, please, you know, it's much deeper than just what happened in Effingham County. The only thing that I have to save my dropouts, my sex trafficking victims, and even my own children are the homeschool laws as they're written. So please leave them as they are. Thank you.
Thank you, ma'am. I appreciate that. Let's see. I think, does anybody else, going once, going twice, want to hear, would like, any member of the public that would like to speak on House Bill 530? So, okay, there's one gentleman and one young lady, and so y'all can form a line. Introduce yourselves to the committee. Because you didn't sign up, you only get 1 minute. And I will wave and turn the mic off. So, because apparently the wave just isn't enough. So, Chairman Cantrell keeps laughing at me. So, thank you. Introduce yourself to the committee.
Madam Chairman and committee, thank you for allowing me to speak. My name is Bethany Beecham, and I've been homeschooled all 15 years of my life, and I know that my family appreciates the way Georgia currently approaches home education. One reason we as homeschoolers oppose this bill is that it requires extra work to be completed that serves no practical benefit, such as lines 22 through 24. Now, don't get me wrong, child abuse is unlawful and wrong. However, hard, difficult, and emotional cases often end up creating bad policy and hurting the innocent, who are often the masses. Research has shown that homeschooled parents are no more likely to abuse their children than others. Moreover, more government regulation has not been shown to reduce child abuse, as tragic as those numbers are. It's unfair to treat homeschoolers and those seeking to withdraw their children from a public school like criminals. Homeschooling is awesome. While some children learn well by sitting at a desk, some learn better hands-on, and others by standing on their head or jumping around the room. Homeschooling allows the child to grow in whatever direction they wish to.
Thank you. Good job. Thank you. I do apologize. Introduce yourself to the committee.
I'm a homeschool dad. I'm a sergeant first class in the military army at Fort Benning right now. Question is, when me and my family moved to Georgia the first time, we started homeschooling. Then we came up and saw how the school scandal came about. Then if we would have had our kids in school, we would have moved back to Texas back in 2015, but we came back with the military again for this time last year, 8 months ago. If we take our children out, then what happens is if we move another city, another state, we're not tracking from the state, from Georgia. So what will happen to our kids? That is one of the questions asked. What will happen?
Oh, okay. Hold on. You have a quick question from...
Yes, sir.
I guess that was alluding to my question. So when you leave the state, what do you do? Do you report to someone where you're going?
In Texas, you don't have a declaration of intent.
So, but if you were in school in Georgia and you get moved, what do you tell your local school system that you're going to the new school? Is that how it works?
We're homeschooled, sir. So
if you were in the school system,
right.
though.
So we do home. We already have our intent, but other people that's in Fort Benning, what they want to do is they'll take their kids out of school, and then they have to do the intent. But when they move again for PCS, then what happened to them? Because they're gonna fall off the system.
Okay.
So if they go to a state like Texas where you don't do an intent to homeschool, then they fall out the system. How do DFAC become a play in that?
Thank you.
Okay, thank you. And I will, just because we have to kind of, the gentleman in the flag T-shirt is going to be the last one. So, ma'am, you introduce yourself to the committee.
I'm Tara Newton. I'm a homeschool mom of 3. We live in Rincon, Georgia, which is Effingham County. What happened there was tragic, and I appreciate the intent behind the bill. I understand that we all want to protect children. None of us want to see these things happen. But this is not the way to do it. This bill came out of an emotional case. Emotional decisions are rarely good ones. We don't need to fall back on emotions right now. We have to look at what actually failed these kids, and the fact that they were pulled from school was not what failed them. Thanks.
Thank you. Introduce yourself to the committee, please.
Madam Chairman and committee, my name is Amy Auger. I am from Forsyth County, and just to answer some of your questions, my son was in 6th grade at Liberty Elementary or Liberty Middle School. We decided to pull him out because, again, he was not being met at his needs. He was advanced and they didn't have the funding to do what they needed to give him what he needed. So when I withdrew him, I submitted the DOI, and I got a call from the school. I had to go to the school. I had to fill out a withdrawal form. From my understanding, that's a Forsyth County requirement. I don't know if that's county to county, but I did have to go in and fill out an attendance and a withdrawal form with the school so that otherwise they were threatening me with a truancy case. So my child, who did not have any issues, there was no issues, no behavioral issues, no attendance issues, that was how it was handled.
Okay. Thank you, ma'am. I appreciate your coming and sharing. Introduce yourself to the committee, please, sir.
My name is Michael Mercer, and I'm 15 years old. I go to a hybrid program called Eras Academy. I used to go to J.J. Daniel Middle School. I was pulled out of that middle school because of disciplinary reasons that were not my fault. I was assaulted by a middle school robotics teacher, and the principal and the assistant principal did not believe my story. They were unfair to me and called me a liar straight to my face. Homeschool has been the best thing that's ever happened to me. My grades have improved from D's to F's to A's and B's.
Thank you. Okay. At this time, the Juvenile Justice Committee is going to suspend consideration of House Bill 530, and we are going to allow for public testimony. It's for hearing only for House Bill 440. So therefore, you're welcome to stay. We are still, the bill still is on the agenda, but we will suspend consideration right now of House Bill 530 and move on to House Bill 440. Relative to House Bill 540, the Juvenile Justice Committee is going to suspend for just a couple of minutes while everybody shifts.
so in the back of my truck.
Raucous party people of Juvenile Justice, simmer down. I have an update. The will of the committee, we are going to suspend consideration of House Bill 530. We will take up the matter again tomorrow morning at 8:30 in this very same room. So I do apologize for that, but they're still working on language, and I know committee members have other commitments, and we are now going into 2.5 hours for the hearing. So, and we still have other matters to consider. So we will take the matter up again tomorrow morning, 8:30 in room 506. So that's the status of House Bill 530. Sorry. Moving on. We will begin hearing on House Bill 440. We are working from LC 480049. This is on for public comment. So Brian Nunez. It's okay. Okay. You know, I will probably just, are you Maria? I am Michelle. Okay. Okay. You're the third one. Would you like to go ahead and start? That would be awesome. Okay. All right. I'm turning. Yep. The mic, it should be live now. Thank you.
Thank you, Madam Chair. I would like to thank you, Madam, for allowing me to speak in front of the committee today. And my name is Michelle Zuluaga. I actually work with the Georgia Shift. We are a nonpartisan, a nonprofit organization that works on engaging youth with our democracy. First, I would like to state that we support this bill and make that clear. Second, I would like to make a simple question to the committee. If a person is not considered an adult until they are 18 years old, why are they tried as an adult at 17? If a kid is not able to vote or have a say in a system that will completely impact and change the discourse of their lives, why do we put them in a position where they are being treated as an adult and tried as an adult? For second, I would also like to say that we should give the opportunity for these kids to to vote and sorry, I apologize. To vote and to have a say in their democracy and to be tried as adults when they are 18, and that is a big reason why we should raise the age. When people are teenagers, they make mistakes, as we have all made mistakes when we were young. Being caught up in a system that is the juvenile justice system, it is easy to be caught in a cycle. So please, I also want to urge the committee to put this bill up for vote today, because I understand that it's only for hearing. This is our youth we are talking about. This is the future, and not only the future, but the present. I urge for this bill to go on to vote and to not only just be up for hearing. Thank you, Madam Chair.
Thank you. Maria with Georgia Shift. I'm sorry, I can't read that last name. I'm too vain to put my glasses on. Shh. Yes, ma'am. If you'll introduce yourself to the committee, please.
Okay, wonderful. Good afternoon. My name is Maria Palacios. I am the Advocacy and Policy Chair for Georgia Shift. We're a nonprofit, nonpartisan organization headquartered in Augusta. We operate statewide with 18 to 24-year-olds in particular on campuses, getting them more involved in civic engagement, politics, local government, things like that. I really wanted to speak on HB 440, and thank you, Madam Chair, for introducing a wonderful bill that I know in Georgia has been needed for a very long time. As you all may already know, Georgia is one of a handful of states that still automatically tries people as adults at the age of 17. And when I think of this issue, I automatically think of our youth who are 17 who maybe get in trouble for traffic things. Maybe they sped, a speeding ticket turned into an arrest where they went to adult prison. And from there, the devastation, the impact of youth who have never experienced our criminal justice system from that standpoint, what that has on their confidence moving forward in their abilities to make positive decisions, especially when those things cost money, cause attorney fees. I say this having a 17-year-old brother who went through the criminal justice system for that very reason. I also think back to, I grew up in Gainesville, Georgia. I grew up with a lot of friends who had broken homes, who their parents worked a lot, and so they sometimes got into trouble. And as soon as they were 17, fell into our criminal justice system. And those friends did not get to go to college like I did. Those friends didn't get to graduate. Those friends don't get to work in the wonderful jobs that I've feel very honored to experience. Again, because at 17, they experienced the criminal justice system from a perspective that they were way too young to understand. I know all of these things are important to each of you as we continue to raise our young leaders here in the state. And I urge the committee and chairwomen for you to consider the urgency of the 17-year-olds this year that are impacted in that way. I know when you apply to college, you check off a box whether you've gone to jail or not, been convicted of a crime. Well, convictions in the juvenile justice system don't go into those considerations for higher education like they do for 17-year-olds who've had to experience that. And for that reason, I ask that you all consider pushing that through with urgency this year. But thank you nonetheless for having sponsored and introduced it.
Thank you, ma'am. I appreciate it. Just for those of you just joining us, the Juvenile Justice Committee will, it's essentially tabled suspended deliberation of House Bill 530 at this point, and we will be meeting again tomorrow at 8:30 in this same room. So just wanted to make sure. I know we had some folks that had been out in the hallway join us, so just wanted to make sure that everyone was aware. Brian Nunez from Georgia Shift.
Good afternoon, Madam Chairwoman. My name is Brian Nunez, and I'm the Policy Coordinator for Georgia Shift. We are youth-led, focused in Augusta, and we are nonpartisan, nonprofit. And I'm just here to just give you some stats of why the urgency of this bill is definitely needed. As of 2018, 503 people admitted to prison under 20 years old are part of the prison population. So that's 2.7% of the prison population. 64 of those admitted were 17-year-old, which, to just put you, that's 0.35% of the total prison population. 252 people admitted who were 18-year-olds are also part of that. And 119 people released in 2018 were admitted as 17-year-olds, which is 0.64% of the total prison population. 22 of those were 16-year-olds, 4 of those were 15-year-olds, and 3 of those were 14-year-olds. So the main thing that I am here to just is to tell you the urgency that we need this bill. Georgia, unfortunately, is one of the few states that does not have a raise the age bill. Every other state, almost all of them in the South or around us in the Southeast have a raise the age bill. So I definitely encourage it. And other than that, we also have the fact that why is it that we're considering them adults where they can't even lobby themselves as a citizen or tell us about how they feel about these bills. So Madam Chairwoman, once again, thank you for speaking, and I urge you to vote on this bill and make it a priority for this year. Thank you and have a good day.
Thank you. I appreciate your comments. Caitlin Barnes with Barton Law Center. Welcome. I obviously know who you are, but if you wouldn't mind, just introduce yourself to members of the committee. Yeah, excellent. If you'll provide them to the intern, he'll make sure all committee members get them. Thank you and welcome. And I appreciate your patience. Everyone here for 440 or 438, I really do appreciate your patience.
Of course. Thank you for hearing it despite the late hour. We really appreciate it. Good afternoon, members of the committee, Madam Chair. My name is Caitlin Barnes. I'm an attorney with the Barton Child Law and Policy Center at Emory Law. The Barton Center, through the work of law students and other graduate student interns, provide direct representation to youth in delinquency proceedings in juvenile court and represent youth who have been charged and tried as adults in their post-conviction relief proceedings. And we use those practice insights that we have gained to advocate for evidence-based policy reforms for the systems that affect kids in foster care and the juvenile justice systems. Raising the age of criminal responsibility to 18 has been a central focus of the juvenile justice reform conversation in Georgia for at least 20 years, with legislative proposals to similar to HB 440 having been introduced as long ago as 2000 and periodically thereafter, most recently by Representative Mary Margaret Oliver. The interest of lawmakers, advocates, and other stakeholders has been to eliminate the discrepancy in state law that allows a child to be placed in foster care for his or her protection until age 18, but treats the same child as an adult if he or she breaks the law. This discrepancy still exists. The Barton Center represents youth in foster care who have been arrested, often for trauma-induced behavior in their placements. When arrested, these youth often remain in jail as neither the state nor their parents are able to make bail for them. We also represent 17-year-old clients who are denied necessary special education services as they sit in jail. The Barton Center, along with our partners, Voices for Georgia's Children and Georgia Appleseed, led the research and advocacy efforts that ultimately led to the passage of the comprehensive revision of the Juvenile Code rewrite in 2013. Thanks to the leadership of the Deal administration and this Georgia General Assembly, that new code shifts the state's response away from an over-reliance on expensive restrictive custody and to evidence-based programs in the community, saving taxpayer dollars and through a more effective public safety approach. At the time that the new code was developed, raise the age was part of the discussion, but had to be set aside. It's really considered to be the unfinished business of the steadfast reforms of the past 5 years. I'd like to respond to two concerns that often come up when we talk about raising the age in Georgia. The first is the concern that raising the age will make it more difficult for the state to hold violent offenders accountable and to keep our communities safe from crime. By design, the juvenile justice system is equipped to assess and address the needs of juveniles and the risk that they pose to our communities. Juvenile court judges understand juveniles' social, behavioral, and developmental needs, and they have the authority to provide and prescribe interventions that are right-sized to the particular individual before them. This includes counseling, supervision, and, when necessary, restrictive custody. Studies tell us that the juvenile justice system works. Youth who are adjudicated and served in the juvenile justice system are 34% less likely to reoffend than youth who are charged and prosecuted and incarcerated in the adult system. That's 34% less likely to recidivate. Raising the age would mean more youth could benefit from the rehabilitation provided by the juvenile justice system and return to their communities, not as criminals, but as contributing members. The second concern I'll address is regarding increased caseloads and the associated costs of raising the age for our juvenile courts and the Department of Juvenile Justice. These concerns were raised in all of the states that have raised the age of criminal responsibility during the legislative process. There were predictions about hundreds of millions of dollars that would be needed to implement the legislation, and that the juvenile system would be overwhelmed by the new cohort of juveniles coming into the system. Despite these predictions, other states have been able to fold the new cohort of juveniles into their juvenile justice operations with limited or no budget increases. For example, in Illinois, money that was set aside in the budget to account for the increased caseloads went unused. They never had to use it. They never had to tap into those additional funds. The impact to the systems in other states was less severe than predicted for two primary reasons, both of which are true in Georgia. First, juvenile crime rates nationwide have been dropping since 2006. That's based on data from the United States Department of Justice. Second, those states that have raised the age of criminal responsibility did so as part of a broader effort to move juveniles out of expensive, secure detention and back into the community to receive services that are more effective at rehabilitating young people at a lower cost. Again, so the reduction in crime and the adoption of more cost-effective policies left room open in the budget and in facilities for this new cohort of youth. Again, both of these factors are true in Georgia. We know that juvenile arrest rates have been dropping since 2011 at least, and the new juvenile code, again, was designed to reserve the use of that expensive restrictive custody for the highest risk cases and serve more youth in the community at lower cost and with greater effectiveness. Raising the age of criminal responsibility is a significant next step in Georgia's criminal and juvenile justice reform efforts, one that the Barton Center supports. We hope to serve as a resource as you continue to consider this important policy change, and thank you so much for your time.
Thank you very much. Members of the committee, do y'all have any questions? All right, thank you.
Thank you so much.
Polly McKinney, please come forward, introduce yourself to the committee, and do you have any handouts or anything?
No.
No? Okay.
Not today. I could have, but I didn't. I'm sorry.
I know. I like those fact sheets.
No, well, we'll get there. Hi, I'm Polly McKinney. I'm the Advocacy Director at Voices for Georgia's Children, and we are a birth through 21 to 25 full whole child policy and advocacy shop. And I will be brief because the hour is late and because I like to be brief, usually. I just have a few points that Caitlin did a great job of sort of laying out the landscape. And the only things that I would like to add are that studies about brain development support the idea of keeping young offenders in juvenile court until at least the age of 17. Health experts confirm that the brain's frontal lobe is referred to as the executive part of the brain. It's sort of the rational part. And it's not fully developed until kids are about 25. That part of the brain regulates decision-making, planning, judgment, and impulse control. And this explains a lot of teenage behavior when you realize that your brain's not fully cooked until you're about 25. Current law also, this is my other point, also shuts out parents of 17-year-olds. So if a kid turns 17 and the child is arrested, the officers are under no obligation to contact the parents. And we find that there's polling that shows that an overwhelming majority of adults believe parents should be involved when anyone under the age of 18 is arrested. When a child is arrested, under 17, parents are called and they become involved usually as a child travels through the court system. And it's important for kids to have that support. And by contrast, as I said before, when a 17-year-old is arrested, police in Georgia don't have to call the parents because 17-year-olds are legally adults in this circumstance. Children who are susceptible to coercion may also agree to plea bargain without any parental input. In many cases, parents do not find out about their child's arrest until it becomes a barrier in college applications. And families, we just think families should be involved throughout the court process. And then I just want to sort of emphasize what Caitlin said about the juvenile justice system does a great job of holding children accountable and giving them the services that they need. Much more so than an adult court, kids are able to access, they can be sort of forced to stay in school and forced to get therapies and things like that they really, really need. And so with that, I would say Voices for Georgia's Children supports this legislation. And thank you.
Thank you. Are the committee members, do you have any questions for Polly McKinney? All right, seeing none, thank you. Kendra, hello. Do you want to speak on 438 or 440? 440, okay. Welcome and introduce yourself to the committee.
Hi, I'm Kendra Mitchell, and I'm the lobbyist for the Georgia Association of Criminal Defense Lawyers. GACTL does fully support HB 440. a personal anecdote from my practice as a criminal defense attorney. One of my first cases I had was a lady who was charged with battery against her mother. The mother had called the police. She was 17. Here she was 17 and in a situation where she needed to get some services through the juvenile court. Defects had been involved and was involved, yet she was being prosecuted criminally. When we were able to get pretrial diversion for her, her mother kind of put wrenches in the system so that she couldn't get to her probation appointments, etc. So my point is that 17-year-olds that find themselves caught up in the adult system, it produces absurd results, and it frustrates the intention of kids who may be in an abusive situation and who want to clear their name. The last time I talked to this client, she was looking forward to college and was hoping that she would be able to complete PTD so that she could move forward.
Okay, thank you.
And with that, we are in support.
Okay, and members of the committee don't have any questions? Thank you, Ms. Mitchell. I appreciate that. Mark Hayden. I was worried you'd given up on us. I didn't see you back there.
Chair and members of the committee, I really appreciate this opportunity, and I'm going to give you a 2-minute testimony, which I think you'll really appreciate. My name is Mark Hayden. I'm a Georgia resident, and
If you could speak into the microphone. I just know that there are people,
Sure.
and I'll get a text from somebody going, I can't hear what he's saying. So if you could
Sure.
just speak into the microphone, please. Thank you.
My name is Mark Hayden. I am a Georgia resident, and I'm the Director of State Government Affairs at the R Street Institute, which is a free market, center-right think tank that supports limited, effective government in many areas, including criminal justice reform, and that's why House Bill 440 is of special interest to us. As it stands, Georgia is one of only 4 states that automatically prosecute certain minors as adults, and there's a reason why the supermajority of states have moved away from this. Trying all 17-year-olds as adults is patently unfair in our opinion. If you can't trust these people with opening up a bank account or getting their ears pierced on their own, then clearly they shouldn't be held to the same level of responsibility in the criminal system. But this policy also, it burdens minors with adult criminal records that are going to follow them for the rest of their lives, making it hard for them to ever get a decent job, and it may prevent them from enjoying certain rights and privileges. But placing minors in adult prisons, which this can be a consequence, also creates other forms of negative outcomes. These individuals are 34 to 77% more likely to recidivate than those who remained housed in juvenile facilities. But this policy additionally places youths in other forms of harm. Youths comprise less than 1% of the adult prison population, but they're the recipients of 21% of sexual violence in prison. And these youths are also 9 times likelier to commit suicide than their counterparts that remained in juvenile facilities. And as already has been mentioned, science backs up that there's a lack of culpability in many of these youths because the part of your brain that helps you develop rational behavior and understanding cause and effect doesn't fully develop until sometime after your 17th birthday. But besides all these issues, punishing all 17-year-olds as adults wholesale is unnecessary because there's other methods within the legal system that permits minors to be treated as adults on a case-by-case basis, depending on the severity of the crime. And for these reasons, the R Street Institute fully supports this bill, and when it does come up for a vote, we hope that you'll give it serious consideration. Thank you so much.
Thank you. I appreciate your testimony before the committee. And there is no one else that has signed up to speak on 440. Have I missed anybody? Please speak up. I have not. As I don't know, I want to let everybody know kind of the posture of 440. It is kind of an ongoing conversation that we have. We will continue this throughout the session, and we will continue this during the off season, so to speak. And I do hope that something will be ripe for action next January. So we are, I don't want anyone to lose hope. There are very, very significant fiscal implications, and also a group of folks that are near and dear to my heart, our poor juvenile judges. It will greatly increase their workload with a move like this. So we need to make sure that we have the infrastructure in place, that the court systems that we're going to be referring these juveniles so in need of services to, that they're going to be, that infrastructure is going to be in place, and that they are resourced enough to be able to handle that influx. So I appreciate your patience. And there's a question at 25.
Question for the author.
Sure.
I'm certainly for this. Is there any groups organized or that think this is not a good idea? Are there anybody that's kind of battling you on this?
There's a lot of passive aggressive behavior, and I'll leave it at that.
Okay. But there's no official, like we've heard from official groups, there's no groups that are organized.
No.
Okay.
No. There's no one saying, boo, send 17-year-olds to jail,
Right.
and treat them as adults. Nobody is that, but there is an extraordinarily amount of passive aggressive, and there is just a certain inertia. Changing a seismic change like this does take a certain effort and a certain will. So.
Okay. Well, I appreciate the effort. I think it's a great idea.
Thank you. If you're willing to help, I'll rope you in. All hands on deck. So anyway, but that is kind of how we're moving forward on 440. So we are going to move on now to House Bill 438. We just have a couple committee members. I love you and I appreciate you hanging with us. On 438, we just have 3 folks that are signed up to speak, and I will recognize Darlene Lynch. And if you'll introduce yourselves.
Sure. Thank you, Madam Chair, members of the committee. I'm Darlene Lynch, and I'm a fellow with the Georgia Women's Policy Institute. And we are here today in support of House Bill 438, which we believe adopts a common sense approach of restraining children in Georgia's juvenile courts for good cause only, after consultation with the sheriffs and the child's attorney and a review of the risks in each individual case. Today, most states in the nation, 31 of them, plus District of Columbia, have abandoned the practice of routine restraints on children in their juvenile court. They did this in the face of growing evidence that automatically restraining children is not necessary for courtroom security and is harmful to children and their prospects of rehabilitation. States that have adopted measures like HB 438 include Florida, North Carolina, South Carolina, Tennessee, Kentucky, and last year, Louisiana passed a statute very similar to HB 438. While some states have ended the practice by statute and others by court rule, they all have 2 important things in common. 1, a presumption against restraining every child who comes into court, and 2, and an exception to that rule for when the court finds it's necessary to shackle in order to prevent the child from escaping or from harm to the child or to anybody else in that courtroom. And these 2 essential elements are what are recommended today by the National Council of Juvenile and Family Court Judges, the Association of Prosecuting Attorneys, the National Association of Counsel for Children, the National Juvenile Defender Center, and the American Bar Association, who issued a resolution in 2015 against routine shackling. So although most states have moved away from this practice, it still does exist in Georgia today. And the Georgia Women's Policy Institute conducted an informal survey of public defenders across the state. And we received responses in 7 of the 10 judicial districts. 75% of the respondents reported that children are routinely made to appear in court in handcuffs, leg irons, and belly chains. And it does not matter how young the child is or how small that child is or how minor that child's offense is. It's just routine practice in many courts around Georgia. We also found some good news that I wanted to share, and that is that there are some judges who, on their own accord in Georgia, have developed protocols that comply with best practices out there in the nation and are similar to HB 438. And Judge Michael Key from Troup County is one that we've been speaking with. And Judge Key has a protocol that allows restraining of children for only 3 reasons, or one of 3 reasons. 1, it's necessary to prevent physical harm. 2, prevent flight. Or 3, the child has had a history of courtroom disruption and is likely to do that again. With that protocol in place since 2015, he has only used restraints twice, and he has had no incidents or problems in his courtroom. No one has escaped, no one has been injured since 2015. And we've uncovered other positive examples. In Chatham County, which has a similar protocol, the public defender there reported observing only one child restrained in 4 years and no incident. In Macon, the assistant public defender couldn't recall a single incident in the past 2 years involving an unshackled child. And we find this happening across the nation. And I'll just point out one in particular, Miami-Dade. They've had a presumption like this for more than 10 years. 30,000 children have gone through that court system, and they have not had one single escape and not a single injury. And you can find examples like this across the nation, in Texas, Louisiana, New Mexico, Nebraska, all across. So in closing, GWPI appreciates the work that Georgia's Council of Juvenile Court Judges has done to come up with a rule. But we want to alert the committee that their rule is very different from the rule recommended by the National Council and the kinds of measures that are being put into place by all of our neighbors and other states around the nation. The rule that's been proposed simply asks judges to develop his or their own local protocol for their court and to put that protocol in writing. But it doesn't require that that protocol have a presumption against shackling. And it doesn't require that exceptions only be made for good cause. And so our concern is that children will continue to be shackled unnecessarily in certain parts of this state, but not in others. And restraining a child in juvenile court should depend on the risks that child poses, not on where that child lives. And for these reasons, the Georgia Women's Policy Institute urges you to support HB 438, and are happy to provide whatever support we can as this goes forward. And thank you for this opportunity.
Thank you. I appreciate that. And I would also like to recognize that she was the CASA of the Year for DeKalb County. So, yay. Yeah. I sit on my local CASA board, so I love my CASAs. And next we have up Kendra Mitchell would also like to be heard. It's like we're getting the band back together.
Well, first of all, I want to apologize, Chairman Ballinger, for my inability to properly sign up today.
You're on the list.
I'm on the list. Yes, thank you. I just wanted to express that GACTL is fully in support of 438 as written, and that is all I had to add.
Okay, thank you. Let's see. We have Maya from the Barton. I'm not, if you'll introduce yourself, so I know how to pronounce that last name. That would be awesome.
Sure. Good afternoon, or evening now, I guess, Madam Chair and members of the committee. My name is Maya Lakshman, and I'm a public health graduate student at Emory, as well as an intern at the Barton Child Law and Policy Center. Thank you all for your time today and commitment to this issue. I am testifying on behalf of the Barton Center in support of HB 438 and will describe how juvenile shackling endangers juveniles' rights to due process and a fair trial and causes psychological harm. Appellate courts have limited the use of physical restraints during court proceedings for several reasons. First, the use of physical restraints undermines the presumption that a person is innocent until proven guilty. The presumption of innocence is a fundamental part of the administration of justice, regardless of the age of the defendant. The U.S. Supreme Court has held, without an individualized finding of need, shackling undermines the fairness of the fact-finding process, as it implies that the individual has been prejudged to be dangerous and guilty. Second, the use of physical restraints interferes with the ability of juveniles to communicate with their attorneys, both orally and in writing. The Sixth Amendment guarantees that all juveniles have the right to counsel in delinquency proceedings. The attorney-client relationship is about building trust and open lines of communication, especially during court proceedings, during which attorneys and clients often speak or write notes to each other. The U.S. Supreme Court has also held that physical restraints interfere with a person's ability to communicate with their attorney or with courtroom personnel, in conflict with the Sixth Amendment right to counsel. Third, there is evidence that shackling children causes them shame and humiliation that might have long-term negative consequences on their psychological well-being as well as self-image. When juveniles appear in court in physical restraints, it adversely affects their self-image as well as confidence and increases feelings of alienation. But studies show that when juveniles feel respected by the system and are fairly treated, they are more likely to comply with court orders. Psychological research additionally suggests that the use of physical restraints can have long-term negative consequences as they interfere with the adolescent development of identity. For the 75% of youth in the juvenile justice system that have experienced trauma or abuse, and the 65 to 75% who have mental health conditions, those negative effects are compounded. In light of this evidence, the Barton Center supports the policy presented in HB 438 because it would preserve juvenile court judges' authority to use physical restraints when public safety demands it, while protecting juveniles from unnecessary harm and promoting juvenile due process rights. Thank you so much.
Thank you, ma'am. I appreciate your comments. And save the best for last, Polly McKinney. We got started at 2:30, but no pressure. But no pressure. So we started this.
I'm ready. Got my tap dance shoes on. Hi, I'm Polly McKinney, as you heard already today, Advocacy Director of Voices for Georgia's Children, and I rise in support of the bill. Just to bring you back to your childhoods, I think it's really important for people to remember not just the shame and humiliation of going to court, but also what it actually physically feels like for a child to be shackled. I hope that none of you ever were, but I think it's an important and traumatic experience. Yeah, wait, don't count. That's not help. But I think it's a visceral thing, and it's something that can cause trauma to a child, and trauma is one of those things that we work about in child policy all the time to minimize so that the child can be productive moving forward. And I would also like to just add that study after study has shown that the whole scared straight concept doesn't actually get results. So if that's the intent of shackling, and I'm talking scared straight, like going into the adult jails and things. But if that's the intent, I'm not sure that we're getting the outcome that we desire.
Yeah. And we will attack trauma-informed care at a later date.
Yes.
So it seems like sometimes the state creates problems that it needs to solve. So I appreciate everyone's patience. I appreciate committee members for hanging with us. We will meet. I do have a question.
I'll be really fast. I'm going to ask you the same question I asked on the last one, only because when I'm doing legislation, I try to spend all my time with people who are opposing me. I get down the road further. Anybody opposing this?
There is some pushback from folks that, this has been the default for a long time in the state of Georgia. So there's a little, what are we doing? Why are we doing this? Are you picking on me? Is there a problem? There's kind of some natural suspicion whenever there is a policy that we have been adhering to for perhaps too long. So change and inertia sometimes are, is difficult. So
okay, thanks. Good bill.
Madam Chair.
Thank you. Oh, Judge Whitfield. Yes, Judge Whitfield is a retired judge from Cobb County, retired juvenile court judge from Cobb County.
I'm only going to take a moment just for the committee's information. I'm Jim Whitfield, senior judge, juvenile court, immediate past president of our council. I think Ms. Lynch mentioned our rule that our council has proposed. And I think one clarification I want to make so you don't have a misunderstanding. I believe our rule does have a presumption against, because it starts out, a juvenile may not be physically restrained during a court proceeding unless such restraint is authorized by court order or local protocol of the court. And then goes on with regard to the written protocol requirements describing under what circumstances restraints may be used and considerations that need to be made. That's the only point I wanted to make, and don't want to belabor the already long day. Appreciate the hard work of this committee. Thank you, Madam Chair.
Thank you, Judge. You do have a question. Chairman Cantrell.
So, Judge, is it your opinion then that this law is unnecessary, this change?
I believe that's obviously a policy decision for this committee and for the legislature, but as a council, we would prefer our uniform rule because it does provide for some flexibility within the various jurisdictions and circuits based on what their resources might be, based on their physical situation. Many times juvenile courts are having to share courts with other courtrooms or in alternate locations with regard to personnel that's available in a particular courtroom, based on, you know, are sheriffs in the juvenile court, are they not in the juvenile court? Those varying circumstances. We think the uniform rule and a written protocol that has the presumption, no restraints, but identifies when restraints could be used, would be more flexible and would be more beneficial to our courts.
Would not the, if this law was changed to what's in 438, would not that flexibility still exist for the judge to say, well, today we have, maybe it's a resource issue. We don't have enough LE in the building to run the risk of, I don't know what it would be. I'm just,
Yes,
you know, does it not still retain that same flexibility?
I don't think so, because under our proposed rule, the protocol would be in place. Under the proposed legislation, if restraints were to be used, you have a hearing. Somebody's got to make a motion, the judge has got to enter an order with findings of fact. The only way we can enter an order with findings of fact is when I have testimony from somebody on the witness stand that says, these are what the facts are. And then I resolve those facts and make a determination on the restraints. It could result in a lot of hearings. Sometimes those hearings may last longer than the actual underlying procedure would be.
Okay.
For example, you have a child that comes in on a Friday afternoon for a detention or probable cause hearing. They've just been arrested. It's a probable cause hearing. Those hearings are usually very quick, okay? They may be an issue with regard to the restraints, and it may take longer to argue about the restraints and what the history is.
I get your point.
Under the rule, hearing wouldn't be required, but still you can have that information in an informal method with just a colloquy at the bench. The sheriff comes in and says, Judge, this child is really acting up in the back. They're not following any rules. We have a concern about safety here. Hear from the defense attorney, hear from the district attorney, make a decision, enter the order, move on with the hearing. I think it would be a more efficient process, and that's where the flexibility is.
Last one, Madam Chair.
Sure.
In part, this is an ignorant question, because you may have said this already. So that rule that you just talked about, is that is the policy for every court, juvenile court already in our state?
No, sir. This is a proposed rule.
A proposed
it has not yet
policy.
been approved and adopted by the Supreme Court. It is in that process along with a entire rewrite of the Uniform Rules of Juvenile Court. Uniform Rules of Court, however, do have the force of statute if there is no statute that conflicts with that rule.
Okay.
The statute would take precedence, but if there's not a statute, the rule has the force of law, and it would cover every juvenile court in the state of Georgia.
Well, I, for one, I won't speak for the rest of the committee, but I, for one, would love to see a copy of that rule. If you could email it to us.
All right, sure. I actually can email it to you, Representative Chairman Cantrell.
I don't have copies,
okay.
but I have one I'll be glad to give up.
Okay.
If y'all
okay, and Chairman Welch waves. Ladies and gentlemen, hearing no other business before the committee, we will be back at 8:30 in this very same room to hear House Bill 530. We are adjourned.